Good evening, everyone. Welcome to the Hidden Histories Collective. I'm LaChris Robinson Jordan, historian and genealogist. And here we are on July the 4th. I had to do this particular video today. It was critical, it was crucial, and it was necessary. But I also wanted to say some things. I was initially going to do a reaction to the Birthright Citizenship ruling, which I will be talking about, but I wanted to kind of expand the conversation and do a bit of a civics lesson, if you will, because I really feel like that's what we need. We need reminders. We need to understand what the Constitution really says and really kind of do some gleaning of meaning, if you will. So we're going to dive right in. And here's the roadmap for this presentation today. We're going to definitely get into what does birthright citizenship mean. Then we'll move to the naturalization clause in the U.S. Constitution. We'll be talking about the Naturalization Acts of 1790, 1795, and 1802. Then we'll, of course, move to the 14th Amendment, Dred Scott, and Reconstruction. Then we will, of course, talk about Trump versus Barbara and the Supreme Court ruling. And then where are we now? Immigration enforcement. So there's a lot to unpack today, but I'm going to try to make this as efficient as possible so that we can continually we can move on to other matters. So one of the things I want to first say before we get really, really deep and started is I want to say that sometimes people forget that the US Constitution is based deeply in the indigenous ways of life. And in 1988, there was a resolution that Congress passed acknowledging the influence of the Iroquois Confederacy on the development of the US Constitution. And this resolution also reaffirmed the government to government relationship between the US and American Indian tribes. Now, I find this really interesting because most of us are not taught this. We're, taught that the US Constitution is this great document and these men got together and they wrote it and it was signed. Okay. But there's a lot more to it, as we know. And some time ago, I did a presentation on the U.S. government was built on Indigenous law. I'd encourage you guys to go look at that video because I go into more depth about how the Constitution came to be, who were the players, and quite frankly, how that particular Constitution took some time to come together because it wasn't just a document that was written and signed. It was several years that the Constitution became what it was. So I just wanted to talk about that before we dive in and get started. So what does birthright citizenship actually mean? And this is something I've been wanting to really talk about because when we hear the term birthright citizenship, we always talk about it in political terms. And we often hear it in the media. But I want to say this and stress this, that the term is not ever used by the Constitution. It is never written. It's never used as a phrase. The 14th Amendment is really explicit in saying all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So there's no term called birthright citizenship. It is purely political and media driven. Now, I want to take a moment and talk about birthright from an Indigenous perspective, because that to me is really the foundation of how we move as Indigenous peoples. Now, one of the things about birthrights is it's not just what we receive in the way of physical land and inheritance, it's also what we remember, preserve, and pass on. And the land is only one part of our birthright. It's also about the memories that our ancestors pass on to us, the sacrifices that they made for us, and then all of the stories that they've told us. And those are the things that we hold dear to us. And that is also part of our birthright, is that knowledge, because that knowledge also helps us with our traditions, with our teachings, with our language, and our ways of understanding the world. And so there is a responsibility that we have to pass this on. And of course, many of you, I'm sure you are aware of this and know this within your own families, that we all have various skills, things that we've practiced, craftsmanship, and things that we've learned to survive and have actually lasted for generations and generations. Like, for instance, my mother was a master at using her hands. And what I mean by that, she sewed, she made quilts, she made pillows, she did a lot of macrame, and she was also an incredible gardener. She loved to take care of plants. We had so many plants in the house. I don't know how she did it. I really don't. And she was also an incredible cook. She was also a baker as well. So when I think about my mother and her hands, I think about what she gave to me. Now, I'm not a baker at all. I do love to cook, but I don't bake at all. But I've used my hands in a different way. I write. I'm a writer, and I've been writing since I was a child. And I probably have, I don't know, maybe over 100 pieces of intellectual property in the time that I've been a writer, writing screenplays and books and novels and all of that. So I use my hands in a different way. But it is through that knowledge and understanding of my mother that I begin to appreciate, yes, the way in which she used her hands, and how, in using her hands, she took those skills and abilities and was able to take care of the family. So all of those skills we take with us, and we carry that forward, and that is totally part of our birthright. There's also history and our responsibility to preserve it and tell the stories of our people, right? And there's a responsibility to all of this. So when we talk about birthright from an Indigenous perspective, that is what we are talking about. It's not just something that a government entity has said, "Oh, you've been in for you've definitely you're eligible to become a citizen." So, birthright citizenship is, to me, very much a contradiction, because no one can give you citizenship. No one can give you birthright from a cultural perspective. We understand the legal dynamics of it, but when I talk about birthright, it's inherited and it's a belonging to our culture. So, I also wanted to give you guys the definition of American. Now, many of you have probably seen the 1828 Noah Webster's dictionary definition, but I wanted to just show it to you all from a historical perspective as we begin to talk about American. Now, when we see this original definition, it's pertaining to America, of course, right? But then look at the noun. The noun says a native of America, originally applied to the Aboriginals or copper colored races found here by the Europeans, but now applied to the descendants of Europeans born in America. So what's really interesting, as they said, yes, the Aboriginals were or are called American back in 1828 and prior, and then the descendants of the Europeans then called themselves American. So I just wanted to share that with you guys, because I always find that that's a very interesting jumping off point to the discussion of what is American. because as people celebrate the 250th anniversary of the quote unquote birth of America, there was always something that came before. And I definitely want that to be acknowledged. And of course, as Hidden Histories Collective, we're going on record to say that we have been here for thousands upon thousands of years. And we understand that the US government is 250 years, but this continent, this landmass, right, has been here for a very, very long time. But anyway, I wanted to also then go back to looking at the definition of Aboriginal. And here, 1828 Webster's Dictionary says first, original, primitive. Now we know that was what they saw and thought of us. Aboriginal people are the first inhabitants of a country. Aboriginal tribes of America, that was their example of how Aboriginal was used. So I just wanted to show that, and so that you guys saw how we were originally described. And then when you look at the definition of Aboriginal as a noun, it says an original, right? And the first settlers in a country are called Aboriginals, as the Celts in Europe and Indians in America. Now, this is how they defined us back then. And we know we're much more than this, but I just wanted to give historical context to these definitions of American. Okay. So now this is where we get into the meat of the discussion here about naturalization, because I think it's really, really important to have this discussion prior to jumping into our discussion about the Supreme Court ruling, because many of you know, and probably, I guess you could say, predicted that they were going to uphold Wong Kim Ark. But of course, I say there's historical dynamics that got totally overlooked, which is why Justice Clarence Thomas went scorched earth on his dissent. But we'll get into that later in a minute here. But I wanted to talk about the moment of 1790 to the Reconstruction era. Now, one of the first things I want to note before we dive into that is that when you look at the naturalization clause in the U.S. Constitution, Article 1, Section 8, Clause 4, the text of the clause says, Congress shall have power to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. So basically, that was their way of saying this clause gives Congress the exclusive power to establish a uniform process for foreigners to become citizens of the United States. Now, this was written in 1787, ratified in 1788, and then it became effective in 1789. Now, why this is very important is because when they talked about the Naturalization Act of 1790, they were talking strictly of quote unquote free white persons. We were not even thought about in this Naturalization Act that Congress put together, but it was their first federal naturalization law. And part of the naturalization process meant that you had to be a free white person. You must have lived in the United States for 2 years, must have resided in the state where you were applying for 1 year, and you had to demonstrate good moral character, took an oath of allegiance to the United States, and then petitioned a court. And once approved, the person became a U.S. citizen. So the reason why I'm showing you guys this, there's a couple of more acts after this one, is that the naturalization process was already in place prior to the 14th Amendment. So many of you guys know where I'm going with this. So there was already a naturalization process for those who were in the United States. Now, fast forward to 1795, and now you're saying that people have to have been in the country for a little bit longer, like 5 years, right? So they amended that, revised that, made some more changes. But then now we move into 1802. Now we are expanding this Naturalization Act even further. And so the process is the immigrant arrives, lives in the US, files a declaration of intention, waits several years, petitions a court, and this time produces witnesses who can testify that they've lived here long enough, they're good moral character, they swear an oath, and the judge signs the naturalization certificate. So, all of this is saying that people had to go through a process to become a US citizen, and they had to pledge an oath of allegiance and basically, say, okay, I'm pledging the oath of allegiance to the United States, and that's it. No other country. Okay. So, of course, this begs the question, if you were born here, were you a citizen then? Okay. Because many children born in the United States to white immigrant parents were generally treated as citizens before 1868, even if their parents had not yet been naturalized. Okay. And the foundation of that was common law, and it's called jus soli. A person born within the territory was a natural born subject to recognized exceptions. Now, the only issue with that was that it was not in the Constitution. It wasn't explicit at that time. And so the understanding came from common law and judicial practice, not from an explicit constitutional provision. Not until the 14th Amendment. But here's where things get really interesting. And this is where the current Supreme Court, of course, I question their reasoning when it came to birthright citizenship, because there was already a naturalization process for free white persons, but none for the enslaved, or the formerly enslaved, I should say. So when the 14th Amendment was passed, it was part of three amendments: the 13th, abolishing slavery; the 14th, giving people equal protection and guaranteeing citizenship; and then the 15th Amendment, which protected the right to vote. So you had, and all of these historically have been called Reconstruction amendments. So what I'm saying here is that if there is already a naturalization process in place for free white persons, you wouldn't need to have another amendment to say, oh, okay, we need to guarantee you citizenship, because that was going to come down the road eventually. But you definitely needed to do it for those who had been recently, quote unquote, emancipated. Okay. So I really want people to understand the history as to how the 14th Amendment came about, because you had certainly many more millions of enslaved people than you had white immigrants. Okay. So again, let's look at the timeline a bit for the 14th Amendment. Now, in 1866, it was proposed by Congress. The 14th Amendment was proposed on June 13th, 1866. Now, the Civil War had officially ended, and I think it was April 1865. I have to look at my dates. But then after that, the amendment was ratified on July 9th after meeting the required 3/4 of states. So basically, from 1865 to 1868, the 14th Amendment was adopted during the post-Civil War years amid the Reconstruction debates about freedom, citizenship, and equality under the law. Okay, so the original purpose, again, was about ensuring citizenship for formerly enslaved people and to overturn the effects of Dred Scott versus Sanford. Now, remember, Dred Scott that case came in 1857. And so that case was definitely about saying, hey, this particular quote unquote man is not really considered a citizen because he's a slave or a former slave. So I won't get into the whole issue of Dred Scott, but I just wanted to say that part of the 14th Amendment was overturning that particular decision. So now we're going to move into the Executive Order 14160 and start talking about the Supreme Court ruling that basically upheld Wong Kim Ark. Now, the facts are the case that the executive order that was written by President Trump it sought to end automatic citizenship to children born in the United States whose parents were unlawfully present in the United States or temporarily present, such as tourists, students, or certain visa holders. I really wanted to kind of stress that because what people thought that Trump was doing was ending birthright citizenship, and he wasn't ending birthright citizenship. He was trying to make definitely saying, hey, folks who are having children here who are not lawfully present need to have birthright citizenship not be an option for them. So I just want to stress that the focus for him was people who were unlawfully present in the United States. Now, what happened was we went through this whole process. The U.S. Supreme Court ruled 6-3 that President Trump's executive order restricting birthright citizenship is unconstitutional. And on the face of it, yes, it is, because Congress is really in charge of that, making sure that those laws are on the books and what have you. But as I've said in previous birthright citizenship videos, the only way that this could even be put on the table was for Trump to write the executive order, because no one had stepped forward to basically say, I've been injured by this particular birthright citizenship issue, and Congress has not, I don't know when they will, has not stepped up to be really clear about whether having an unlawful parent here is problematic to someone having birthright citizenship. So, because it's constitutional, it's quote unquote correct, right? So, the 6 justices that ruled for it, as you could see, Roberts, Sotomayor, I always say her name incorrectly, Kagan, Brown Jackson, Coney Barrett, and Kavanaugh. And of course, the dissent from the other justices, Clarence Thomas, Samuel Alito, and Neil Gorsuch. So, of course, they're known to be the originalist on the court that stick very much to the original intention of the Constitution. Now, Chief Justice Roberts wrote the majority of opinion, and the majority concluded that the Constitution, historical precedent, and more than a century of case law support birthright citizenship. And they upheld the case United States versus Wong Kim Ark from 1898. Now, again, I won't go into a lot of detail about Wong Kim Ark, but basically his parents were Chinese nationals, and they were lawfully domiciled in the United States. And unfortunately, they weren't able to become citizens because of the Chinese Exclusion Act, but they were, like many Chinese, given permission to live here legally within the United States. And Wong Kim Ark had gone on a trip, come back, and they basically told him that he wasn't a citizen. They took it all the way to the Supreme Court, and they said, yes, he is. So, but I often say about Wong Kim Ark is that his parents were lawfully domiciled here in the United States. So when you think about the Naturalization Act, the Naturalization Clause, you know that you have to go through that process. But in his particular case, as a Chinese national, they weren't allowed to do that. So eventually his parents did go back to China because they knew they would not have the opportunity to be U.S. citizens, despite the fact that their son was. So basically, birthright citizenship, it remains in place. And the ruling leaves birthright citizenship in place for nearly everyone born on U.S. soil. Okay. Now, as we know, the 14th Amendment protects birthright citizenship, and every child born in the U.S., regardless of their parents' immigration status, subject to narrow historical exceptions, they will be considered U.S. citizens. Now, one of the things that came out of the decision and the ruling was that the executive branch had said that constitutional citizenship cannot be defined by executive order. And we pretty much knew that. It's defined by the Constitution, not by the president. So again, everyone is protected by the citizenship clause of the US Constitution. Now, the dissenting opinion, this is where it gets really, really interesting, okay? Now, Justice Clarence Thomas authored the principal dissent, and Justices Alito and Gorsuch also dissented. They wrote their opinions as well, and they basically argued that the court has misunderstood the citizenship clause for generations, right? And of course, Thomas, when you read through his very lengthy dissent, he talks a great deal about the original purpose of the citizenship clause and how it was adopted after the Civil War to ensure citizenship for formerly enslaved people and to overturn the effects of Dred Scott versus Sanford. Now, in Thomas's dissent, he wrote the longest opinion during his tenure on the Supreme Court. I think if you were to put it in words, if you were to take all the words that he wrote, it'd be the equivalent of a small novel. He went scorched earth on it for real. And he kept citing Dred Scott. And he cited Dred Scott 31 times. And his quote was, "The court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed Blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support." I think it's really interesting that the Supreme Court, the justices, did not look at the naturalization clause and how that affected essentially what it meant to be a citizen for people like Dred Scott and other enslaved people, right? So that's my thing, that it's not just about this Barbara versus Trump case. It's also the ethics behind how this particular ruling came to be. That's just, I'm just going to say it. Like, there is an ethical dynamic here that has to be taken into account and understood. So basically, in the dissenting opinion of all of them, they talked a great deal about the subject to the jurisdiction thereof. And that was what was part of the focus. They talked about allegiance, domicile, the meaning of that, and then foreign jurisdiction. Yeah. So basically, the dissenting opinion, in summary, the dissent contends that children born to individuals who are only temporarily or unlawfully present were not originally intended to receive automatic citizenship. Automatic citizenship, because again, you had to go through a whole naturalization process to even be a U.S. citizen. So, we can go back and forth about it, but again, when you look at the history of the Constitution and what is written there, it's quite clear that you had to go through a process to be a citizen. There wasn't anyone coming in and just, oh, I'm going to be a citizen and everyone's going to benefit. No, it was a specific process. Now, I broke it down a bit to show you guys the author opinion length comparison, because again, Thomas, he went there. He went completely there. It's I haven't even finished reading all of it. I read so much of it, but one of the things I can appreciate about his dissent was that he put on record, cited a great deal of case law, a great deal of law, not just related to these various cases, but the constitutional law. Like, he went there. So, and I'm sure Justice Thomas said to himself, I may not live to see what happens next, but I'm going to at least put this down in the historical record as to how this law or how the 14th Amendment and citizenship should be interpreted. And I have much respect for that. Much respect for that. So I'm also going to be providing you guys a link to all of the arguments, the blog, the Supreme Court blog, so that you guys can really read this for yourself, really internalize what's being said. Because again, people are going to debate and go back and forth about this for years to come. This is really not over. And I'm going to get into that in a minute here as we come to almost the end. Like, yeah, I want to say I'm almost done, but yeah, time always flies here for some reason. So basically, the majority versus the dissent, they presented fundamentally different readings of Reconstruction history. But I mean, if you guys read it, I mean, it's so different. It's like night and day. And I just go back to what the Constitution says and what it required of citizens, what it required of the Congress after even the formerly enslaved were set free. The enslaved were set free. It's amazing how the interpretations were so different, but that's why you have 9 justices. That is why you have people from various backgrounds on the court, because there's no, sometimes there's no slam dunk on these decisions, but it played out in real time. But I'm going to move forward into the where we are now, because one of the things that I noticed about President Trump was I did see him moving with anticipation of the ruling not going in the favor that he had wanted, which he knew constitutionally he couldn't write an executive order. He was really forcing the law, really forcing the system, and he did get what he wanted in terms of getting into the Supreme Court. But in doing that, now the debate still continues. Birthright citizenship is still unchanged for now. The executive order remains blocked. Thomas's dissent is now part of history, Supreme Court history even. And the original meaning of the 14th Amendment will continue to be debated. But you guys know the final chapter on birthright citizenship may not have been written. And the reason why I say that is because the dilemma still remains. The child is a U.S. citizen, but the parent status does not change, and the mixed status issue still remains, which is what Thomas was also speaking to when he dissented, was that he said the framers were intelligent enough to know that they weren't creating contradictions in the U.S. Constitution. On one level, they're going to say, hey, be naturalized, go through this whole process. But then on the other end, oh no, you don't have to go through the process. Your baby could be a U.S. citizen without anybody being a citizen. So he was, to me, my personal opinion, correct in saying that the Constitution was really clear in what was expected of Congress to do, what was expected of citizens to do, which is why we had the amendments. Of course, they were not part of the original Constitution, as we know, but as we know, the amendments serve the times, and those are issues that cannot be, altered or changed, such as the Civil War, right? So when we talk about citizenship, naturalization, and the 14th Amendment, we also have to understand the larger immigration system around it. Now, we're close to ending the presentation, guys, but I want to show you a quick clip of what's been happening recently and how ICE is really going to town when it comes to immigration enforcement.
We're seeing our arrest numbers come up. We're seeing our deportation numbers continue to increase. Right now, we're deporting on average over 3,000 individuals. Actually, the average has been for several weeks now, over 3,200 individuals a day. 70% of those individuals we're deporting have outstanding criminal charges on them, or they've already been charged with a felony. 70% of those individuals. 70% of the individuals that are men and women throughout DHS arrest, being ICE, CBP, or one of our other components, 70% of those individuals have pending felony charges or are current felons that shouldn't be on our streets. So when we go after the worst of the worst, which is exactly what we're doing, we're saving lives. This is a statistic I like to put out, but 50% of the individuals killed in Fairfax County, Virginia, are killed at the hand of an illegal. Over 41 individuals year to date have been killed in Tennessee at the hands of an illegal. 100% of those deaths are preventable because those individuals shouldn't be in this country. So when you say surge, we're surging every day because we're trying to restore law and order, regardless if you live in a red state or a blue state. But sanctuary cities create a safe haven for criminal activity, and it shouldn't take place. Regardless of what your opinion is about this administration, regardless of what your opinion is, if you're a Republican or Democrat, we should all agree we should want safe streets and safe cities. So there should be no argument in participating in arresting the worst of the worst. But because of some of the radical policies we have that's happening right here in New York, with a mayor that's not even wanting to fully fund the NYPD, which is, I would arguably say, one of the best law enforcement agencies in the country, and not giving them the resources they need, speaks volume of a socialist's mentality.
So, wow. So as you guys can see, this, the administration is not playing around at all. So on one level, yes, you can have a baby here on U.S. soil, and that baby will be a U.S. citizen. But as far as the undocumented are concerned, it's becoming increasingly difficult for them. Increasingly difficult. And it's a new era of immigration enforcement. And just recently, before the Birthright Citizenship ruling, Congress approved $170 billion through 2029. And what they're going to be doing is expanding the funding for ICE and immigration enforcement, increased detention capacity and deportation operations. They're also going to be doing additional border security, infrastructure, and technology. And there's going to be thousands of new federal immigration positions created. And I mean, they've already been doing it. It's already in effect. So on one level, President Trump said, okay, you're right. I can't write an executive order and change the Constitution. But what I can do is enforce the immigration laws that we have in place. Yeah. So that is where we are. That is how things are, unfortunately, for the undocumented. And also, there was also a Supreme Court ruling back and on June 25th that ended temporary protection status for Haitians and for Syrians. I think it was like 350,000 Haitians and 6,000 Syrians. But they've been ending temporary protection status for other countries as well. So that's real too. So there's a lot coming down the pipe in terms of deportations, and I will say we have not seen the end of this yet. So, but again, thank you all for watching the Hidden Histories Collective. We're so excited about having you here with us. We are now over 8,000 strong. I love that. And please feel free to share this video, like and subscribe and all that great stuff. And please, please, please sign up for our newsletter. There are some exciting announcements coming as well. And for those of you, many of you probably know that I'm also a filmmaker. And there is an episodic series that we are going to be launching pretty soon here. And you guys will start hearing about that in the fall. And I'm super excited about it because it's historical, it's epic, it's it's pretty big. It's a pretty big deal for us. And we can't wait to share it with you guys. So please sign up for the newsletter. We'll be making those announcements pretty soon this month. And yeah, we are excited about it. So again, thank you all for watching, and we will talk to you all soon. Have an amazing, amazing evening.